Hey there, welcome to Help Solve the Case. I'm Christine Burke, and we are talking today about the Alex Murdaugh case. We've got some more documents filed about some testing and some things that they want to do in between his retrial. So let's get started and talk about that. I want to say thank you for being here. I appreciate all the likes, the shares, and everything that you guys are doing to help me help support my mission with this channel. So thank you very much. Okay, this is a packet of a couple motions. They came out, I'm a little bit behind. We've got a lot of filings on some cases. This is June 24th. And I had originally talked about that they wanted to do some DNA testing for material, biological material recovered from under the fingernail. So we're going to talk about that. It says defendant Richard Alexander Murdaugh, through undersigned counsel, hereby moves for an order requiring the state to produce DNA evidence in this case for independent laboratory review. And that's an important statement because who's going to pay for it? Okay, so they're asking the state to produce DNA evidence. So it sounds like that there was material, there was evidence recovered, but it was not tested. So they're asking the state to produce it, well, to produce the DNA evidence for independent laboratory testing. So let me correct myself on who's going to pay for it. The grounds for this motion are as follows. DNA evidence was collected from underneath Maggie Murdaugh's left-hand fingernails at the scene. And it says SLED. That's the South Carolina Law Enforcement, I believe, Division or whatever. That's the state agency. It says SLED. Y'all South Carolina folks, correct me if I'm wrong. SLED item number 70. SLED determined this DNA was from an unknown and unrelated male. Now, where have we heard those terms before? Unknown, unrelated male. In our recent Tyler Robinson case, right? Are you picturing the statistic in your head? And that makes me want to go back, if the trial documents are public, if those DNA documents are public from the first case, we want to take a look at that, and we want to look at those statistics and how that was done. And as I'm going to post another video today and talk about it, I'm going to talk about those statistics and the experts and those things. Do we need to go back in these cases and do another deep dive related to the DNA? Sorry, that's a lot of alliteration, I think they call it. Okay. So they determined this DNA was from an unknown and unrelated male. No further analysis was attempted. Where have we seen this? And again, I was having a discussion with a geneticist colleague, lab colleague of mine, saying, we have all these cases where this DNA is present and it hasn't been tested. And me, as a police official, right back in the day, as a detective investigating the case, I would be like, whose is that? I would not want to leave it uncovered. But we've seen in many cases, Kohlberger, like all these bombshells about, what is this? Who are these people? Who are these other people? And I want to know. I'm sure you want to know. I'm sure the defendant wants to know. So this is great that they're doing this testing. But here's the answer. No further analysis was attempted. It says this evidence, however, is crucial to the defense. I think it's crucial to everybody. Wouldn't you want to know? For example, they say, testing of, this is filed by the defense if I didn't say this. For example, testing of initially unknown male DNA found at the murder scene is what eventually exonerated David Cam of the murders of his wife and children. I don't know who David Cam is. Cam's 2 prior wrongful convictions were overturned because the prosecution improperly introduced prejudicial character evidence. It says Henry Henderson. Okay, that's a precedent that they're citing. Okay. Defendant's counsel therefore contacted Othram about the possibility of more thorough testing. Othram is a well-known company specializing in the use of forensic genetic genealogy to resolve unsolved murders. That's what the defense is stating. Counsel today learned that Othram believes it can conduct a more thorough analysis of the sample, but the testing takes considerable time and a, quote, rush order would be needed. Defendant therefore moves for an order requiring the state to deliver the DNA sample to Othram by appropriate means for testing at the defendant's expense. Now, I want to know, did they do YSTR on this? Because I could give them an ethnicity and some information, some possible surnames. So was that done? What's the answer on that? I want to know what's going on that. Okay. Here's another one. Motion to transfer venue. Defendant Richard Alexander Murdaugh, by and through his undersigned counsel, respectfully moves this court, pursuant to the 14th Amendment to the United States Constitution, Article 1, Section 14 of the South Carolina Constitution, so we got both in there, and the common law powers of the court set forth in State v. Harvey and State v. Law, case they got precedent there, for an order transferring venue of the trial of the above referenced indictments to a county outside the 14th Judicial Circuit. I don't know where that would be. The basis for this motion is that this is among the most heavily publicized criminal prosecutions in the history of the state. For years, defendant, his family, and the law firm with which his family was associated for generations have been the subject of saturating, sensational, and continuous media coverage. We talk about semantics, right? Those are some saturating and sensational. I don't recall reading that with regard to publicity. Those are some really descriptive words, right? That coverage has been especially intense within the 5 counties, okay, they're going to tell us, that comprise the 14th Judicial Circuit: Allendale, Beaufort, Colleton, Hampton, and Jasper, where, could be Beaufort, don't get on me, where the Murdaugh name has been synonymous with the local legal system for nearly a century. You hear my twang coming out. Where the population is small and interconnected, and where the very documentaries, books, and films have shaped public opinion were researched, filmed, and produced. Under these circumstances, the defendant cannot obtain the fair and impartial trial guaranteed to him by the federal and state constitutions in any county within the 14th Judicial Circuit. A transfer to another county within the same circuit would not cure the prejudice, because the saturation and the personal connections that give rise to it extend throughout the circuit. For these reasons, and for reasons which will be set forth in a supporting memorandum of law filed at such time as the court may direct, defendant respectfully requests that the venue be transferred to a county outside the 14th Judicial Circuit. Okay, now we have a motion for defendant to have access to case materials in electronic format. And this is interesting because I know some of the defendants that I work with, the paper is, it's very hard to manage in the cells if they're incarcerated. They toss the cells, they take the paper, they do the stuff. It's very disorganized. It's not secure. So if he has a tablet or whatever, let's see what he's going to say. So it looks like, because he's still in custody, right? So it says, defendant Richard Alexander Murdaugh, through undersigned counsel, hereby moves for an order requiring the South Carolina Department of Corrections, SCDC, to allow him to review case materials in this matter on a secure laptop computer. The discovery in this case is voluminous. We're going for the big words today, right? And if printed, would fill numerous bankers' boxes. Yes, it would. Merely printing, but I don't know how they're going to fit that all on a laptop. Well, I guess if they get a gig, some good gigs, because the discovery with the body cam and the video and all that stuff, man, you guys, you can blow out. I have multiple terabyte drives just to manage the data. Okay. I'm just thinking about online access and stuff like that. Okay. Merely printing hard copies of the discovery would be far more expensive than a laptop computer. Probably would. Mr. Murdaugh therefore proposes that his counsel provide SCDC a laptop computer with an encrypted, password-protected hard drive for his use, external drive probably, when reviewing case materials in preparation for trial. Maybe, maybe not. I'm not sure where they're going with that. When Mr. Murdaugh is not reviewing case materials, okay, this computer would be secured in the warden's office or some other suitable location, okay? Maybe he'll get it. I don't know. The device would not have cellular capabilities and would not otherwise be connected to the internet. Okay, so they're going to put it on an external drive. Okay, I was concerned about that. The device would not be used to video or audio record anything prior to written approval from the SCDC if lost or stolen. Its contents would not be accessible without the password. This would be a much more secure method of providing Mr. Murdaugh access to materials in his case than sending several banker boxes of paper, a great many of which are sealed or subject to a protective order to a prison. Okay. Yeah, the discovery is challenging. Here's a certificate of service, okay, that it got sent. Okay, so those seem to be the new filings. I'm going to put this in the bullpen, in the Help Solve the Case bullpen, and we're going to keep up to date, see what the answers have come in. If you hear of anything or see of a document that I have missed or anything related to this case or questions that you have about this case, and please remind me, I got to go back and try to find that initial DNA. If you guys know, because I didn't follow this case in the beginning, if the initial DNA identification that wherever they talked about some unknown male, I want to see what type of testing that they did on it and who testified. Okay, what we were talking about earlier. So please let me know. So thank you. I really appreciate your likes, shares, and subscriptions to this channel. It really, really helps the mission, identifying the unknown humans and solving the hundreds of thousands of cold cases, which include a poop ton of untested sexual assault kits. We just have to get this done. Okay, so I will see you on the next one. Hey gang, I just wanted to pop in and talk about, I was looking for this original document for the SLED document about this item number 70 or report number 70. And what I'm seeing here is that, let me read this from the trial transcript, location 3286 to 3289. The defense was questioning Sarah Zapata. And Alex and Paul were excluded. 3 foreign male alleles were detected. The amount was insufficient to generate a full DNA profile for CODIS. Okay. Zapata referenced touch DNA, right? Transfer DNA. They call it touch DNA, but if you think more about a transfer. And this was on February 13th, 2023, during day 16. And we don't have that. Okay. So what they're talking about here is the SLED analyst testified 3 foreign male alleles were detected beneath Maggie's fingernails, not enough to create an identifiable profile. Defense is now asking Othram to determine whether modern testing can extract more information from the remaining sample. So until we get further, I haven't seen that item 70, evidence item 70, but that's what it looks like we're looking at. Can Othram do something? Can Othram or any laboratory do something or not? Supposedly, we heard from, in the Koberger case, that I believe it was 10 cells. Not sure. We will see. So just wanted to let you know about that.